Hey, good morning, everybody. Welcome back to Law and Legitimacy. I'm back in the swamp, here in DC, hopefully getting out of town today. I've got two quick hearings this morning. One will be a change of plea in the United States of America versus Owen Schroyer. You may know Owen Schroyer as the host of the War Room on InfoWars. He works with Alex Jones. Owen has a daily show. I think it's on from like 11 to 3 or 2 to 6 or something. Well, clearly I don't know. I know it's set daily, and it's not the first show in the morning. That belongs to a guy named Harrison Smith. The second show belongs to Alex Jones, and then Owen does the wrap-up. But Owen was present on Capitol grounds on January 6th. He'd also previously been arrested for disrupting one of Jerry Nadler's impeachment proceedings early on, so the feds doubled down. We've negotiated a pretty good deal for Mr. Schroyer in exchange for his guilty plea. He will enter one count of entering and remaining on Capitol grounds, not the building, unlawfully. And under sentencing guidelines, he has a estimated sentence range of 0 to 6 months. It is our hope that the judge will walk him. Because it's Owen Schroyer, because it's InfoWars, the rumor mill is churning, and I've seen a lot of made up news reports along the way that somehow Owen has entered into a cooperation agreement to cooperate with the government against other J6 protesters, including potentially people at InfoWars and maybe the Proud Boys. And then, of course, people leap to the inference that I'm playing both sides of the aisle, and how can I represent Owen as a cooperator and others who aren't cooperating? The simple answer is there is no cooperation agreement. Owen has his own deal with the government. He's not required to provide or offer testimony against anyone else, and he won't. So he will be presented to Judge Timothy Kelly in the District of Columbia here in about an hour and a half. And then a little later, Joe Biggs and Zach Rell from the Proud Boys will be in court on a separate proceeding, this arising from my decision to accept Mr. Rell's invitation to represent him. The question will be whether there is a conflict relating to my joint representation of Rell and Joe Biggs, a client who I represented at trial, at sentencing now and on appeal. Put another way, can I represent Rell and Biggs at sentencing? Can I represent Rell and Biggs at trial? The law recognizes an individual's right to conflict-free representation. Joint representation always carries with it the prospect of conflict. The court has to assure itself that if the clients are aware of this, and then has to make a determination whether if there is a potential conflict, whether it's waivable. We've done our analysis and think that it is waivable. Judge Kelly will have to make his decision. Stay tuned. We'll find out what he does.
Can you talk a little bit about where we are procedurally in the Proud Boys seditious conspiracy case?
Yes.
Convictions have occurred. In the article on the screen there, it talks about post-trial verdict motions or post-verdict motions. Can you talk to our listeners about what this phase is like? Because I think that this is a very shrouded area of litigation, especially criminal defense litigation,
Sure.
Convictions have been secured.
So the convictions, the jury has returned verdicts of guilty on most of the counts. We got not guilty verdicts on some, and they couldn't agree on others. But as far as the main event, seditious conspiracy, the jury has spoken guilty. Now we have an opportunity. The court deferred action on our motion for judgment as a matter of law at the close of the government's case. In other words, we filed a motion saying, even if you take the evidence that the government has presented in the light most favorable to the government, there's not evidence sufficient to go to the jury to prove that there was a conspiracy. In this case, no plan, no agreement, no nothing. The guys showed up. They were agitated and angry on January 6th, and at a moment when things snapped, they crossed barricades and entered the Capitol building. Does that make that a conspiracy? a criminal agreement to use force against the United States government. Our claim at trial was and remains that they engaged in protected speech, even vitriolic speech, even speech that made abstract calls for violence at some future date, which is a protected class of speech under settled First Amendment law. But when they got within the vicinity of the Capitol and the crowd broke, and they broke with the crowd, when the riot began, their actions, their prior speech began to look like criminal intent, and their spontaneous acts began to look like a plan. The government invited, and the court permitted the jury to speculate that this was evidence of a conspiracy. So we'll file motions asking and the court deferred action on our directed or our MJOA motions, our motions for judgment of acquittal until after trial, and entered a scheduling order requiring that those motions be filed prior to sentencing. So when I appeared for Rel and simultaneously for Biggs, the court stayed action on Rel and Biggs motions. However, the court has entertained and received motions from Ethan Nordine's lawyer. Enrique Tarrio's lawyer has joined Nordine's motion. I'm not sure what Tarrio's or what Pizzola's lawyer has done yet. As far as so those post-trial motions offer the possibility that the verdicts will be set aside. It's not a realistic possibility.
I was going to say, yeah. So just, not to extend any sort of pie in the sky expectations for the listeners. These are procedural in nature. You definitely reserve the arguments for appeal. You make every single argument you can at every phase that you can.
Well, one of the reasons you do an MJOA argument, if you're going to challenge sufficiency of the evidence on appeal, if you're going to say to the appellate court, the jury just got it wrong, they were moved by something other than the evidence, you want to obviously have the best argument you can. So by doing an MJOA and a motion for judgment of acquittal motion, you show your hand a little bit to the government, and the government responds by showing it, so that when it comes time to write your appellate brief, you kind of know what they're going to say, and so it's good preparation. As far as sentencing itself, the clients each need to be interviewed by court officers for something called a pre-sentence report. That pre-sentence report will be a comprehensive study of their education, employment, social and medical background, and social relations, and other criminal activity, if any, designed to provide the court with information about the nature of the offense and the character of the defendant. The court takes that information. The parties are given an opportunity to comment on it, demand corrections. In the end, the court will receive that report and adopt them as facts for the court to consider at sentencing. Contained within the analysis will be sentencing recommendations under federal sentencing guidelines. The court is not obliged to accept those recommendations, but they guide the court's discretion. And I raised this and pause on this for a moment because we talked a little bit about this with regard to Hunter Biden earlier in the week. It has been reported that Hunter Biden has entered a plea deal calling for a suspended, the pretrial diversion and no jail time on the misdemeanor offenses of tax, not filing tax returns. That may be what the parties think should happen. A federal judge will make a decision himself or herself about what should happen. And that judge could easily reject the recommendations of the pre-sentence report and impose a sentence of incarceration, even if the parties hadn't agreed to it. And my prediction is that it could happen and should happen in the Hunter Biden case because of the relevant offense conduct in the form of how did he make enough money? Where did the money come from to generate a $1.5 million tax bill? Who gave his lawyer the $2 million to loan to Hunter to pay the back taxes, penalty, and interest? And what did he do to earn all that money? We don't really have any answers. He's a ne'er-do-well without portfolio other than his father's name. And so the relevant offense conduct discussion can blow up in Hunter's face, and probably should. But as to the Proud Boys, sentencing is set for most of them in late August, early September, depending on how Judge Kelly reacts to the conflict issues with respect to Biggs and Rel. Their sentencing will take place either at about the same time or later in the fall. So that's my day in D.C., and that's an update on the Proud Boys and Owen Schroyer.
Well, I guess a question that I don't know how many of our viewers would put themselves in the opposition's perspective, but if I'm part of the prosecution and you are making a motion to, replace Ms. Hernandez as counsel to Mr. Rail. What is their opposition to your doing so? Right. I mean, there's obviously there's two things here that we should make sure to distinguish. One is every attorney's ethical obligation to avoid conflicts that will materially be to the material detriment of their client, right? At all times, an attorney is obligated to act in the best interests of its client. Where certain perceived conflicts or real conflicts can be screened or avoided, one should, but there are some circumstances in which it's obvious that, well, it might not be obvious. After some discernment, it may become obvious that one attorney is not able to uphold his ethical obligation unto each client in the same matter or transaction. So that's separate and apart from, I think, what the prosecution would necessarily be concerned about. Is that right? You know, if I'm the prosecution, I'm concerned that your involvement in any part of this process might somehow taint being able to, like, the fact that a conviction was secured. Is that reasonable to assume?
I see it a little bit differently. I mean, I see the issue, clients have a right to counsel of choice. The lead case there is United States of America versus Gonzalez-Lopez, a case that arose out of Missouri. A court didn't like a certain lawyer who was trying to appear for pro hoc vice from out of district for a client and had reservations about the client's ethics, wouldn't let the client sit. Mr. Gonzalez-Lopez was convicted. An appeal was taken, and the Supreme Court said that the Sixth Amendment right to counsel is sacrosanct, that the client is has control of his or her destiny, including the choice of counsel, and the court abused its discretion and violated Mr. Gonzalez-Lopez's Sixth Amendment rights by not permitting his lawyer to sit. A good friend of mine was the lawyer in that case. That's how I know the facts so well. That right, however, is not absolute. So the Sixth Amendment also guarantees a defendant a right to effective representation of counsel, and that includes representation by counsel free of conflict. When the trial court becomes aware of a conflict, it has an obligation to inquire and to determine, first, whether there is a conflict or a potential conflict. Second, if there is, whether it's waivable. And third, if in other words, whether the clients can say, that's okay, I'm aware of it, I wish to proceed otherwise. And third, if it's waivable, whether the clients are knowingly and intelligently waiving any potential conflict claim. So the government's interest in this case, it's a high profile case. They've spared no effort to obtain convictions. They want to make sure that these convictions, if the case, once these men are sentenced, and judgment enters, then you go to the appellate court for relief. The government wants to make sure that there are no procedural or substantive roadblocks to sustaining these convictions, including a claim of ineffective assistance of counsel because counsel was burdened with a conflict. So they'll want Kelly to take pains to flush the issues that I just discussed out and make an adequate record on that. Judge Kelly's responsibility is to assure that the defendant's rights are protected and that both sides get fair trials. Only the defendants have Sixth Amendment rights to a fair trial and conflict-free representation. The government doesn't have those rights, paradoxically. People always say, "Well, the government doesn't have constitutional rights." No, the Constitution creates the government. But yet it does have rights when the court decides it does. So, for example, the government doesn't have Sixth Amendment fair trial rights, but yet in other contexts, the court held the government has First Amendment free speech rights. And you start to, how is it that the Bill of Rights applies to government sometimes and not others? And the answer is that's why we have a Supreme Court, and that's why people are so confused about the law. The law is just confusing. So, I mean, the inquiry today is just to determine and assure that the integrity of the proceedings remains intact. And these are dots on I's that have to be dotted and T's that have to be crossed.
Careful there, Norm. All right. Well, good. How is the weather in DC? What's it like being back?
I don't like it. When I got out of the train the other day, I thought, oh man, I've got PTSD. I'd spent 4.5, almost 5 months walking from my Airbnb, which is around the corner from the hotel I'm in now, to the courthouse. And, I kind of know the neighborhood, know the characters, know what to expect. And, I was unhappy with the results of that trial. It was an enormous amount of work and a difficult time in life to be away from home. So it's unusual. I went out to dinner last night with Owen, and we talked about the cases and the controversies and the people involved, and it felt like I'd never left at all. So I guess in my psyche I have a permanent home in DC. In my spirit, I can't wait to get the hell out of here. I got a train late in the afternoon. The court knows I've got to be out of there by a certain time. Let's see if I make it. It's possible that if the proceedings run long, I'll have to stay another day. So I don't know. I do not know, as I sit here today, where I'll be tonight.
Heard that. Well, where do you want to go? Do you want to go first to the Massachusetts State Attorney General?
Yeah, let's talk about that. You spotted this very interesting letter. Tell us about it. And well, first of all, I mean, I want to know, can anybody out there, what is LGBTQIA plus? Every time I look at this, there's a new letter on there.
Well, I'm the wrong person to ask. So don't ask me, even though you already did. But what we have here, what I've put on the screen, the Massachusetts State Attorney General, her name is Andrea Joy Campbell. She led what ultimately is a group of 15 states attorneys generals in, I guess, addressing, instructing, and signing a letter to the chairman and CEO of Target. And the nature of the letter is interesting, and we will go through it here and sort of deconstruct it. But before we do, I think, the quick background on this is obviously that, Target has made headlines in the wake of a lot of the Bud Light stuff for its own version of for its own version of a boycott. Target is a publicly traded company the same way that AB InBev, which owns the Budweiser brands, is a publicly traded company. Target has lost billions with a B off of its market capitalization over the last several weeks. And in the wake of a boycott related to merchandise, products, clothes, etc., that were displayed and marketed and promoted regarding transgender, I guess, identity.
Well, Pride. I mean, wasn't it a Pride Month promotion, right? I mean,
sort of. But the problem, Norm, the unique problem that's not addressed. Well, it's addressed in brief here in the letter, or I guess there's a passing reference to it. Is the appeal of these products, merchandise, and displays to young children, right? Tucking, sorts of tucking clothes and bathing suits for very young children. And I think that's important to start with, because what this letter will present is a version of events that, to my knowledge and to the knowledge of the average person, it does not exist. It's something categorically different. And I want us to be mindful of the last several years of riots, of property damage, of burning, of looting, violence all over the place. How many chain retail stores have been destroyed and burnt, forced to put OCB or plywood over their windows and doors in an effort to shield the theft and destruction. So I'd like us to keep that in our mind at the same time as we're analyzing the prose and the rhetoric used in this letter, because it's a pretty convenient appeal to, public accommodations, as it were, in which Target is called. But before we get to the substance, Norm, I want to scroll down to the bottom so that our listeners...
Can I just get my inner redneck out?
Sure.
Why is it that we have to be politicized when we go to the store to buy some shaving cream or some, a bag of popcorn? If I go to Target, I'm not going to have my consciousness raised. And I really don't want to be burdened by being politicized by somebody's view of the good, true, and beautiful. I just want to buy a product and get out of there. And if I walk in and I'm assaulted with a politicizing banner, isn't it my right to walk out and say, I'll take my dollars elsewhere? I'll go shop at a merchant's place. And if I want to be politicized, I'll go to a rally.
Hey, Norm, bake the cake. Okay? Bake the cake. Just bake it. Shut up and bake the cake. Anyway.
Oh, wait. Hey, it's me again. Cy has helped us. L.
She hasn't helped us. No, don't even do it. Don't even do it.
Bisexual. T, transgender. Q, queer or questioning. I, intersex. And asexual, and more. It's the and more that gets to me, you know. Hey,
But
baby, I'm a libidinal mashed potato. Throw me against the wall and see what sticks. You know?
well, look, I mean, it's classic architecture for movements that must continue to appeal to a broader coalition, because the effort that that is being undertaken is not to solve a legitimate public concern. It's really a grifting opportunity. You know, Target gave millions of dollars. As it's me again, the better comment we should have read is the one that she just put in there, that Target actually gave millions of dollars to BLM during the riots, and it didn't shield Target from the destruction and the looting and everything else. But with respect to the LGBTQIA plus platform, the reason that flag continues to change, the reason that more letters continue to be added, right, and the reason that there is a plus at the end is because you always have to leave room to broaden that big tent, because there's no prospect that you could ever fulfill your obligations and your promise to stamp out and secure the civil rights of certain, you know, minority, underrepresented, or oppressed peoples, right? So I'll get off my soapbox there. I do want to go ahead and identify.
Wait a minute. We've got an interesting discussion in the chat. It's me again, Kink. So we're going to put a K in there. In the cloud, wait until they add MAP. I got to ask, what is MAP?
At your own peril, I guess. Here we go. So the 15 states. So, of course, I said it was led by Massachusetts Attorney General.
Yeah, isn't she like 9 years old and hasn't had a real legal job yet, or what?
I did some quick background on Miss Campbell, and it appears that she has had a we'll call it a quick ascension to the office of the state attorneys general. She was sworn in this year in January, but she graduated from law school in 2009, and a short 14 years later has gone from a couple of years at I guess a big law firm, and then, you know, spending some time on the city council in Boston, and then acting as an interim general counsel for a few months, and then also I guess playing a different role for another 11-month stint, has somehow ascended to state attorney general in a very short amount of time. So this is a prestigious position historically in the legal profession, right? Becoming the state's attorney general is one to behold and something to aspire to. So without trying to remark substantively on the merits of her ability to do so, I will just say that it was done very quickly.
It was quick, and this is a woman who, I think if she's ever been in a courthouse, it was only running out after the door hit her in the fanny on the way out. But anyhow, I digress. Go ahead.
Massachusetts, and then we have
Connecticut. Connecticut. Bill Tom.
Keith Ellison of Minnesota. Surprise, surprise.
Oh, well, there you go. I'm surprised he didn't lead the thing, you know.
Well, some of the reports are saying that he did, but obviously Andrea Joy Campbell is the first name there. So Massachusetts, Minnesota, California, Arizona, Connecticut, Delaware, Illinois, DC, Nevada, Maine, New Jersey, New York. There's Letitia James's name. We've said her name on this stream and podcast before. Rhode Island, Vermont, and Washington State. So not exactly a broad coalition of states there with respect to political composition, and not really any surprises in terms of who we would expect among, you know, state prosecutors or state attorney general to put their name on something like this. But let's talk about the substance of this letter. Not sure if you want to take the lead, but I'll summarize by saying what I think I said to you before we got started, which is really interesting, the way that this letter opens up, right? And in particular, in the second paragraph, this is very similar to the conversation that we had yesterday, and in particular, your deconstruction of the write-up from Bloomberg talking about how the Supreme Court was remaking the U.S. and it's, you know, such a boon. Or was such a detriment to certain peoples. But this couple of this sentence here, I'll read just verbatim. LGBTQIA plus Americans have faced an increasing number of politically motivated attacks over the past 2 years. A number of legislatures around the country have adopted laws barring public schools from discussing LGBTQIA.
Okay, so let's pause there. Another way of reframing that is many communities don't want their children sexualized at a young age.
That's where I was going to go with this, right? Because
let's take it one at a time and deconstruct that. So if you don't want your child sexualized, if you pack Johnny off to school with that tuna sandwich, I mean, not tuna, it'll go bad. The peanut butter and jelly sandwich and a piece of fruit and a sippy cup full of juice in his lunchbox, you're hoping he's going to come back and say, A, B, C, D, E, F, G, this is what you mean to me. Not LGBTQIA, what are we going to be today? I mean, and so a parent is right to say, look, let's stick to education. And if we're going to have sex education, well, let's not start it at 6 years old. And if we're going to have sex education, do we really need to pull out a dildo and say, this too can be your new best friend? I mean, there has to be some limit, it seems to me. And so to say that a school board that is barring discussions of whatever that is, the alphabet soup of identity, to say that is somehow represents oppression. It might represent good judgment, good taste, and community standards and discretion. What's next?
Limiting gender affirming care.
Do you want to go or shall I?
Go ahead, Norm.
Mommy, I want my penis cut off. Oh, okay. I'll make an appointment with the doctor. I mean, the doctor that I would be making an appointment with when I heard that call would be a psychiatrist saying, help, this child wants to mutilate the body they were born in. And so I
don't know that I would be introducing my child to the medical or the healthcare industry whatsoever after hearing that, but fair enough.
But I mean, so gender affirming care, that's another buzzword. I mean, you can't drive until you're 16. You can't purchase alcohol until 18 or 21, whatever the drinking age is, but you somehow can decide for yourself, and the schools are, you can decide for yourself that you want to do something as fundamental as change your body type. And then, somehow parents' rights to say no to that are going to be limited in the name of the mental health of their children. Again, community standards may just say, no, this is ridiculous. We're not going to do that. If a child or if a person decides they want to undergo that kind of therapy, well, first of all, it's not clear to me why insurance policies and public insurance ought to pay for, cosmetic identity surgery. That imposes a social cost on the rest of us for what a luxury tax, as it were, on our health care for something that I think is arguably unnecessary and perhaps a sign of some intrinsic perhaps mental health problem that should be addressed head on, as opposed to avoided as opposed to embraced and taken as a sign of our commitment to diversity.
Well, in the limiting gender affirming care, I mean, that's probably the hottest of topics listed here, right? I mean, we'll get to a couple of other things in a moment, but I'd like to just take a second to acknowledge that the limiting gender affirming care is exactly what Matt Walsh of the Daily Wire spent enormous time and resources on in developing his most recent documentary, What is a Woman, right?
Yep.
And what's up, Uncle Pat? So I think that one, the irony is that it's, 4 words, limiting gender affirming care, but this is probably the hallmark issue upon which Americans most fundamentally disagree with where things are going in medicine, in education, and in politics.
And so then prohibiting transgender individuals from using bathrooms or playing on sports teams aligned with their gender identity. I mean, we don't even need to go there. I mean, if I decide I can't cut it as a male track athlete, but I could compete as a woman, and I put on,
Well, Riley Gaines has been in front of Congress at hearings over the past couple of weeks, and there have been all sorts of I guess clips that have come out of there that speak to the ridiculousness. But there is another story that we're yet again not going to have time to get to today, out of South Dakota, whose governor is Kristi Noem. And so the reference there to playing on sports teams aligned with their gender identity is connected in an inextricable way to the NCAA, and the way that the NCAA has tried to wield its money through tournaments and involve I guess certain teams within the jurisdiction of states being able to play in tournaments, right? That is something that they're wielding against state governments, and someone like Kristi Noem bowed right before them and tried to spin it to say, oh, we don't want to incur a lawsuit. Kind of thing.
I saw your jaw clench at the discussion of what's going on in South Dakota. We can do a special session on Sunday if you like.
We should. I think
All
we
right.
should.
So let's do Sunday. We'll announce the time when we've talked about it. This final one in the libidinal alphabet soup. I don't want to remember all the initials. Restricting drag performances. This sort of represents a new low in American public policy, as far as I'm concerned. We've got 13 attorneys general, the highest law enforcement
15.
officials. How many?
15.
Oh, 15. Saying that, it's really troublesome to us that a community might limit drag queen performances for school children. I mean, seriously, this is what the attorney generals have to think about. This
use
is how
of public libraries for this kind of stuff, right? I mean, the point of us highlighting this and deconstructing the language that's used is because language is the primary tool of what's going on to subvert individual sovereignty, community standards, to which Norm has made several references already. It's really important to understand what these attorneys general are saying, right?
Well, and what they're and what's doubly significant is they're not saying, by the way, that Target's breaking any laws. They're just saying these are our aspirations, and we expect you to live up to these aspirations. We're urging you to do so. These are law enforcement officers. They're not moral censors. And the nerve of them to cloak their office in these ideological commitments and to send a letter to Target saying, we don't know, you didn't break any law, but by golly, we're watching you. And if we can find one that you broke, we're going to do it because now we have suspicions about your motives and your behavior in the marketplace. And so will these stores now be subject to extra regulatory scrutiny rather?
I want to take a moment here because this just occurred to me and I don't know why it didn't occur to me sooner, but I guess maybe I understood it subconsciously, but didn't seek to unpack it. The fact that there are 7 letters there, right, with a plus sign at the end. This letter is premised only on one of those letters, right?
Which one?
The T. Everything that's going on with Target right now has to do with but one of the letters in that larger acronym within that larger coalition. So I think it's also highly objectionable, that's putting it nicely, that these 15 states attorneys generals are gaslighting the shit out of everyone, including the chairman and CEO of a publicly traded company that has lost billions of dollars off of its market cap because its consumers, right, have decided that its positioning of certain things in its stores in a certain way to certain demographics was not acceptable. And this is across the country. It's not just in a localized area here or there. It has everything to do with the T. And the fact that this letter tries to embolden this and say that everybody within this coalition has been affected the same way because all the efforts that we just made reference to, right, are across the broader coalition. That is completely fabricated. It's the rejection and the populist opposition to this has been focused on one member of that acronym getting way over its skis and advocating for things that are objectionable to ordinary citizens, to the nuclear family, and certain values that Americans have traditionally represented, right? And that is, these are my children, right? I am not going to allow whatever is going on in public school to affect the way that I'm able to raise my child, right? There are certain fundamental things that we should be focused on. I think you said yesterday, Norm, reading, writing, arithmetic, right? What else are we really talking about? So I wanted to take a second just to point that out because there was a comment in Rumble here that said, I think LGB needs to purge the rest of them. And that's an acknowledgement of what I'm talking about, is that historically the movement, the coalition was lesbian, gay, bisexual, right? And it was limited to that. And, the irony of a lot of this is that, the same sex marriage movement garnered opposition and criticism from politicians that said this was a slippery slope. And at the time they were just labeled bigots, and that opposition was wholesale disregarded as just sort of fear mongering, not based in any reality, et cetera. Yet here we are, right? The reference to the not allowing people in different bathrooms. The city of Charlotte lost the NBA All-Star weekend and NBA All-Star game several years back because of a bill that was in dispute within the city or within the larger state about the use of sex-oriented bathrooms, right? And so I just think it's interesting that here we are on the other side of all of that, and that still
Well,
being.
and what I think is interesting is that as the populist upsurge influences market behavior, as people realize the power that of their individual choices have and their decisions can have over large entities like Target. Target's be responding to the market. They're responding to people, and they're cutting out the elites. They're cutting out the attorneys general. And so this saber rattling by the attorney generals, this gratuitous politicizing by them, frankly, looks like a sign of desperation and a flag of defeat, rather than something to worry about. But
Well, I want to go ahead and say explicitly, this actually reads to me, it transitions from just this sort of, biased, partisan biased, culturally biased narrative at the beginning, right? Gaslighting, as it were, into a threat, a veiled threat. And that's where I'm getting to now. So this paragraph I have on the screen is as interesting as it is troubling, right? So the state's attorneys generals begin saying that there are many legislative mechanisms or legal mechanisms available to Target in an effort to stamp out the discrimination and harassment and blah 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 blah. And this is what I think is crazy that was included here. And this is when I began to feel like this was a threat from these various states' attorney general. Massachusetts, for instance, assigns liability under the public accommodations law, not just to the owners or operators of those accommodations, but to any individual, including other customers or members of the public, who discriminates against others' use and enjoyment of those accommodations on the basis of a protected characteristic like sexual orientation or gender identity.
Yeah.
What is the purpose of saying that? And I know we're trying to wind this up, but here's where it really gets to a point where I think that this is a threat, and I think that we are going to continue to kind of follow this. I'm interested to see how Target responds. I'm just going to read this word for word. Indeed, all our states have laws protecting against discriminations on the basis of sexual orientation and gender identity in places of public accommodation like Target stores. While these laws certainly do not create a legal obligation for retailers to offer any particular merchandise or create any particular displays, they do demand that customers be treated equally. In this context, we urge Target to be mindful of its obligations under these laws as it makes decisions as to how to respond to backlash against its Pride merchandise. It goes on to say, we urge Target to double down on inclusivity, reject hate in all its forms, and stand firm in the face of intimidation and discrimination.
How about the following? We urge Target to sell people goods and services and leave politics to the politicians. You don't need to celebrate Pride Month. We don't need displays of the next identity. We don't need Juneteenth sales. There was a time when you could celebrate the 4th of July without recrimination, but that may itself be a sign of white supremacy right now. Who knows in this godforsaken republic of ours? I hope Target stands firm, and I'd like to see this Massachusetts Attorney General and her colleagues bring some litigation here. That'd be an interesting fight. I think that while people have a right to express themselves, the rest of us have a right to be let alone. And I just don't want to be politicized when I walk into Target. Just don't want it. And if I'm going to be, I'll take my business elsewhere. And I think that's the message here, that you can be effective when you speak up, when you see something that you don't like, you say something, and you reach out with others to create a movement. Target's responded to a community. Some members of the community are unhappy with the response because they're demanding your recognition. The concept of moral exhaustion is, man, if I recognize everybody, I got nothing left for anybody I care about. And at some point, we just have to retreat to zones of privacy where we're stop demanding from others the recognition that is due our idiosyncrasies. If we had common goals, common values, if we recognized authorities, then I'm not talking about political authorities, but moral, intellectual authorities, and we could all seek to learn from them, we'd be a better community. But this commitment to diversity for diversity's sake is making the country into a hellscape. And those of you who are acting up and saying to Target, if you're selling hellscape, I'll buy elsewhere. God bless you. Keep it up. Make those attorney generals hurt.
Indeed. Norm, I always appreciate your diatribes. I think you just got the live chats jumping. I love that. The promise to all of you, thank you first and foremost for being here. We do ask that you leave a thumbs up on this on this video, please share it. If you're not subscribed, do subscribe. If you don't have notifications enabled, please enable those. If you're listening audio only, you know the drill. Leave us 5 stars or leave us alone. And most importantly, we're here every day, 8 a.m. Eastern on Rumble Video Live, YouTube Live, and Twitter Live via broadcast. So thank you for being here. We will be here on Sunday to discuss what's going on in South Dakota. I think we could probably do a deeper dive on that than we would normally be able to do. So what we'll do is talk about the nature of eminent domain generally, what eminent domain is in South Dakota, who the parties are with respect to the bubbling action, and what carbon capture and storage ultimately is and portends to do, and whether that is a sufficient basis for an eminent domain action. Anyway,
do we want to commit to a time right now so people know to tell their wives and husbands and spouses? I can't share family time with you. Mike and Norm are talking.
Let's do 2 p.m. Eastern. I think that's a good slot.
See you then.
See you later, Norm.